Millions of ordinary Americans who have never broken a single law are still waking up in jeopardy. You followed every rule on the books. You purchased your magazines when the statute said it was permissible. You locked them up responsibly. You practiced on the range. You dotted every bureaucratic I. Then, without firing a shot, you discover the same piece of plastic and spring you bought in good faith can now brand you a felon. That is the quiet dread hovering over kitchen tables from Sacramento to Newark. Not because anyone became violent, but because the courts themselves cannot decide what the law actually is. The one lawsuit that could have delivered clarity, Duncan versus Bonta, was yanked back into limbo by the nation's highest court with a single cryptic docket entry: rescheduled. No fresh date, no public explanation, no roadmap. Today, we are walking through exactly what that shrug from the Supreme Court means, what is probably coming next, and why this brawl over so-called accessory bans may chart the next 50 years of the Second Amendment itself. Before we dive in, please tap the subscribe button and the thumbs up icon so the algorithm keeps you in the loop whenever we post an update. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearms statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. What in the world just happened to Duncan versus Bonta? Gun rights forums lit up when the court quietly posted a November 21st conference date. A conference is the private weekly meeting where the justices eyeball a stack of petitions and vote on which ones will get full briefing and oral argument. After months of radio silence, owners in free states and banned states alike circled that Thursday on the calendar like it was election night. Then, poof, the entry disappeared. In its place appeared that single word: reschedule. The case that could have toppled magazine capacity limits from coast to coast is once again drifting in the fog. Why the drama over a scheduling hiccup? Because Duncan is not some narrow California quarrel. It squarely asks whether a state can criminalize possession of hardware the federal government explicitly allows, magazines that hold more than 10 rounds, on the theory that they are unusual or dangerous. If the court signals it will not even look at the petition, every legislator in a purple or blue capital receives a green light to clone California's statute verbatim. We have seen this hesitation before. Snope versus Garland and Ocean State Tactical v. Rhode Island both vanished from the conference calendar, reappeared weeks later, and were ultimately denied. Gun owners remember that pattern like sailors remember red skies at morning. Accessories v. firearms, the priority debate. Critics say the court would rather wait for an assault weapon ban or a handgun case. Their argument is that magazines are only accessories, therefore lower on the constitutional totem pole. Tell that to the New Jersey security guard who was pulled over in 2020. Cops found a factory 15-round Glock magazine he had purchased legally years earlier before the 10-round ceiling existed. No criminal record, no threatening behavior, yet he was charged with a felony that carries prison time and the lifetime loss of gun rights. When mere possession becomes a crime overnight, the distinction between accessory and arm collapses. It is the functional equivalent of outlawing gasoline to ban cars. The 7-year odyssey of Duncan. Picture a legal pinball machine. 2017. California bans the mere possession of magazines capable of holding more than 10 rounds, not merely future sales. Overnight, perhaps 1 million citizens become unindicted felons. 2018. Plaintiffs file suit in federal district court in San Diego. 2019. Judge Roger Benitez, famous for colorful opinions, strikes down the statute, calling it a failed experiment that violates the Constitution. 2020. The Ninth Circuit reverses, insisting public safety outweighs individual interest. 2022. The Supreme Court hands down New York State rifle and pistol assassin v. Bruen, shifting the burden onto the government to show each modern gun regulation is consistent with the nation's historical tradition. Duncan returns to the Ninth Circuit for a do-over. Same court, same plaintiffs, same defendants, but now under the Bruen microscope. Result: the en banc majority again upholds the ban, arguing high-capacity magazines are outside the historical scope of the Second Amendment. Petition for certiorari lands at 1 First Street in early 2023, and then crickets until the phantom conference date that evaporated last month. Bruen's awkward collision with the Ninth Circuit. Under Bruen, the government must produce a close analog from the founding or Reconstruction era. era. California pointed to a smattering of colonial powder-house rules and a late 19th century territorial ordinance. Judge Benitez, now bound by the unpack ruling, was forced to reinstate the prohibition. The conflict is glaring. A regional court of appeals has twice approved a statewide confiscatory scheme, while the Supreme Court insists that text and history is the test. That tension is precisely what makes Duncan an ideal vehicle, if the justices are ready to plant another flag. Beyond California's borders, 21 other states presently impose some form of magazine capacity restriction, and at least 6 legislatures are debating expansions. Colorado recently shaved its limit from 15 rounds down to 10. Oregon's Measure 114 inserts a 10-round cap plus a permit-to-purchase regime. Illinois enacted a 10-round ceiling for long guns and a 15-round ceiling for handguns overnight. Each statute contains slightly different exemptions. Pre-ban possession here, law enforcement carve-outs there, creating a quilt so complicated that attorneys themselves need spreadsheets. A single Supreme Court opinion striking the concept would restore uniformity. Conversely, denial of review would embolden copycat bills in remaining holdout states like Pennsylvania, Wisconsin, and Minnesota. Retroactive punishment by any other name. Call it what you wish, ex post facto, regulatory taking, or plain unfair. But criminalizing previously legal property offends the moral core of the Constitution. Owners had 3 choices when California's statute took effect. 1. Surrender magazines to police departments that had no storage plan. 2. Sell them to out-of-state buyers through a licensed dealer. Or 3. Destroy them. Option 1 meant writing a donation check to the same state that branded you a suspect. Option 2 cratered resale value because supply instantly dwarfed demand. Option 3 asked citizens to smash their own property with a sledgehammer. That is not regulation. It is cultural confiscation wearing a bureaucratic smile. The psychological toll of legal limbo. Every rescheduled conference whittles away at optimism. Social media groups light up with rumors. Clerk said they're holding it for Gazzola. Thomas wants to pair it with goad. Roberts is still searching for that middle ground. Hope oscillates like a heart rate monitor. Meanwhile, traffic stops continue. Prosecutors in banned states charge possessors every week, often tacking on magazine counts after an otherwise routine detention. Each new affidavit filed in county court underscores the stakes. The court's indecision is not an abstraction. It is a cell door slamming on people who thought they were compliant. States exploiting silence. History rhymes. While the court incubated Bruen, New York raced to replace its century-old May issue licensing regime with a Rube Goldberg machine of sensitive place restrictions, live fire tests, and social media background checks. By the time Bruen issued, the ink was barely dry on the successor statute. We see the same sprint today. Legislatures drop magazine bills the way traders sell volatile stock. Get it on the books before the Supreme Court speaks. Every 24-hour delay at 1 First Street equals another week of enforceable bans below. The human cost behind the jargon. Consider John Doe, a pseudonym for a real defendant in Oregon. John bought a standard capacity Glock 19 magazine in 2018 while stationed at Fort Lewis. He separated from the Army, moved to Portland for a tech job, and tossed the magazine into a range bag. In 2023, he was stopped for speeding. A public safety sweep uncovered the 17-round mag. John now faces a Class B misdemeanor, possible jail, and the loss of his concealed carry permit. No victim, no violence, just a polymer box with a spring inside. Multiply John by hundreds, and you begin to see why Duncan matters. Why the court might be holding back. Court watchers offer 3 leading theories. First, the justices could be waiting for a circuit split to ripen. Right now, the 3rd, 4th, and 9th circuits have upheld bans. The 5th and 6th would almost surely strike them, but only the 9th has produced a post-Bruen opinion, so the split is technically still one-sided. Second, the Chief Justice may be shopping for a consensus vehicle. Duncan involves possession, Gazzola involves sales, goad involves importation. Bundle them and craft one clean rule. Third, the court could simply be gun-shy after the media meltdown that followed Bruen. A June 2024 decision that forces half the country to repeal statutes overnight is not the legacy Roberts wants to carve into marble. Whatever the calculus, the consequence is identical. Millions of citizens remain in legal purgatory. What you should do while the drama plays out. 1. Map your state's terrain. Statutes change quickly. Injunctions flick on and off like faulty light bulbs. Follow your Attorney General's press releases and the local gun rights group email list. 2. Consult a specialist lawyer, not the buddy who handled your house closing. Someone who can quote the intricacies of 18 U.S.C. BWRF 922 and state analogs in the same breath. A 30-minute consult costs less than a criminal defense retainer. 3. Build a paper fortress. Scan every receipt, photograph every serial number, cloud backup every PDF. Courts may require you to prove lawful acquisition years after the fact. A shoebox of thermal receipts fades, a PDF endures. 4. Avoid gray area bragging. Posting range photos that show a 30-round mag in the background is evidence, not swagger. Assume every upload is admissible. 5. Keep political pressure rational. File polite comments during rulemaking periods. Show up at legislative hearings and vote in local elections. District attorneys and sheriffs exercise enormous discretion. 6. Maintain perspective. Bruen itself took 18 months from petition to opinion. Landmark cases are marathons, not sprints. Fatigue is the enemy. Steady engagement wins. Denial is not defeat. Even if the court ultimately denies Duncan, the war is hardly over. Catano versus Massachusetts, an unsigned 2016 per curiam, started as a stun gun case so minor it never received oral argument. Yet it forced Massachusetts to rewrite its statute and open the door to Bruen 6 years later. A future petition involving AR magazines, belt-fed devices, or even binary triggers could revisit the same constitutional ground. The lower court judge who upheld California's ban acknowledged as much, practically inviting the Supreme Court to speak more definitively later. Legal setbacks are temporary. Constitutional principles are stubborn. The domino effect if the court grants. Imagine the court schedules Duncan for argument next fall. A June 2025 opinion that adopts Judge Benitez's reasoning would vacate every magazine capacity prohibition in the country, require jurisdictions to compensate owners for confiscated property, compel licensing authorities to restore permits revoked solely for magazine violations, and force legislatures to justify any future numeric limit with founding-era analogs. An evidentiary burden most bills cannot survive. Such a ruling would rank beside Heller and Bruen as the third pillar of modern Second Amendment doctrine. It would also echo in state courts, where analogous state constitutional challenges sit in hibernation. The counter scenario, if the court denies review, a silent denial carries its own message. Accessories are expendable. Expect a legislative tsunami. Rhode Island will drop its 10-round exemption for pre-1994 magazines. Washington will lower its limit from 10 to 7. Illinois will extend its ban to lever-action tubular magazines. Each bill will cite the Supreme Court's refusal as implicit blessing. Prosecutors will feel emboldened. Plea offers will stiffen, and the next cert petition will have to climb an even steeper hill of circuit consensus rhetoric, staying sane in the interim. Uncertainty is corrosive. Build routines that anchor you. Monthly range trips with compliant magazines, quarterly inventory audits, annual legal checkup calls. Treat the law like the weather. Prepare for storms you cannot prevent. Share verified updates only. Rumor is contagion. Support plaintiffs' counsel by contributing to litigation funds. Amicus briefs cost money and often tip the scales in close cases. Finally, mentor new gun owners who bought their first Glock last month and have no idea yesterday's standard magazine is tomorrow's felony. Education is insulation. Closing pitch. The court's reschedule is frustrating, but it is not surrender. The arc of Second Amendment jurisprudence bends toward liberty, but it bends slowly. Duncan v. Bonta could still land on the docket next month, next year, or in the term after that. When it does, the opinion will either cement the Bruen Revolution or tempt lower courts to keep improvising restrictions. Either way, your job is the same. Know the law, document your property, stay politically engaged, and refuse to let fatigue win. The Constitution is not self-executing. It defends itself through citizens who refuse to shrug their shoulders. Keep watching the docket, keep your receipts dry, and we'll be here to translate the next surprise entry into plain English, no matter how long the black-robed marathon lasts. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.